Let's talk about Wells Fargo freezing all of Wendy Williams' accounts and trying to put her in a guardianship. You may know guardianship by another name, the name that's used in California, which is conservatorship. It is the same with a few caveats. Now, in New York, I am not a licensed attorney in New York, but one of the things that attorneys are very good at is research. So based on the research that I have done, what I found easily and terrifyingly is that, anyone can be a petitioner in a guardianship in New York. To get a guardianship in New York, a petitioner has to file a petition asking the court to appoint a guardian. But anyone can be a petitioner. And once the petition's filed with the court then can appoint a court evaluator to evaluate the case. The court evaluator will do an initial investigation, provide the court with a report, and then generally report an opinion. And then the court will decide whether they are going to need to appoint a guardian or not, whether they need to appoint legal representation or not. And then it will move forward to potentially being a guardianship or not. In New York, like other states, you can have different types of guardianships. That can include just a financial guardianship, like Britney Spears had a guardianship of the estate and the person, but there can be a guardian for financial reasons, to pay bills, to stop financial abuse, to take care of planning, but it can also extend to medical care and things like that. I imagine, based on what we've seen, that what Wells Fargo is seeking is a financial guardianship. But the backstory here is also very strange, because you have a financial institution freezing someone's assets and their access to their assets. And then that individual is now having to go to court to say, these are my assets and I should be able to have access to them. And in response to that, Wells Fargo is like, no, but we've applied for a guardianship. We suspect there is financial issues. And I think that is very, very strange. So we're going to pull up all of the timeline documents. We're going to go through what's happened in court, because this started February 4th with a filing by Wendy Williams against Wells Fargo. Petitioner Wendy Hunter, which is Wendy Williams, by and through her attorneys, Miami Entertainment Law Group, by way of petitioner, the attorney that's undersigned, against respondents Wells Fargo, we're just calling them Wells Fargo, brings this special proceeding to ask for the following: that respondent be stopped or enjoined from freezing all of petitioner's accounts, including but not limited to personal, business, deferred compensation, and investment accounts, and interfering with her right to access her financial assets and statements pending a final binding decision by an arbitrator, and alleges as follows. So this is an emergency petition for a preliminary injunction and temporary restraining order. So you can get the temporary restraining order and then move to the preliminary injunction hearing. There's different standards there. Petitioner Wendy Hunter is an individual residing in New York. Wells Fargo is a company that's operating in New York. Jurisdiction and venue, they're all in New York. We're not even going to go over it. Facts common to all causes of action are highly relevant to us. On or about April 11th, 2018, Wendy Williams and Wells Fargo entered into an asset advisor agreement and client agreement, collectively the agreements. So she had a asset advisor that worked for Wells Fargo and became a client of that particular service by Wells Fargo. Upon information and belief, the purpose of the agreements is for Wells Fargo to provide brokerage cash services and to execute securities trades with her accounts. Upon information and belief, I'm not going to say that every time, but then I might, but I'm going to try not to. Wells Fargo is in possession of several $1 million worth of funds belonging to Williams, which are currently managed by Wells Fargo or held in Wells Fargo's possession. For more than 2 weeks, respondent has denied Williams any access, whether online or otherwise, to her financial accounts. And when we say otherwise, we're going to get to how much Wendy Williams has had to go to lengths to fight with Wells Fargo over access to her accounts, including in person. And they have still not given her access to her accounts. For more than 2 weeks, respondent has denied petitioner access online or otherwise, to her financial accounts, assets, and statements. And statements. She can't access her statements. Can you imagine not being able to access your banking statements? I mean, if you're worried about financial fraud or undue influence or whatever they're going to say later, to not let somebody see their statements is so bananas to me. Based on advisement by Williams' former financial advisor, Lori Schiller. This is Lori Schiller's assessment and advisement to Wells Fargo that Williams was of unsound mind. Despite Williams's termination of Schiller as her financial advisor due to Schiller's, they're alleging, malfeasance in relation to petitioner's accounts and Schiller's improper conduct in relation to their professional relationship, Wells Fargo continues to rely on Schiller's advisement as support for its decision to deny Williams access to her financial assets and statements. As additional support for its decision to keep petitioner's accounts frozen, respondent references its authority under the agreements that we talked about above, the client agreement, to, quote, pause or reject instructions for a proposed transaction pending judicial or administrative remedies should they suspect financial exploitation, dementia, or undue influence. However, that provision is inapplicable in this instance for several reasons, including the fact that petitioner has not proposed a transaction for which respondent allegedly has the discretion to pause or reject. So this would be like saying, hey, sell my entire stock portfolio and put it into Dogecoin. Wells Fargo could say, I have questions about why you want to sell off your entire stock portfolio and put it into Dogecoin. That would be a instruction. I have questions. Wells Fargo, have questions about that instruction. So this agreement gives me the right to pause that instruction or reject that instruction because it seems sus. And we can go to court or go to arbitration and talk about it. But freezing of the entire account, all of the accounts, and access to statements for me does not fall under instructions for a proposed transaction. Proposed transaction is the operative word. There's no proposed transaction here. It's all access to all of her accounts. So where's the proposed transaction? I don't see a proposed transaction in freezing somebody's fucking accounts, but okay, we'll continue. As even if the provision did apply, respondent is going beyond the scope of the authority granted by the provision because respondent is completely denying Williams the ability to access or even view, it's the or even view for me, or even view, whether online or otherwise, her financial assets and statements, which Williams has requested for the purpose of ascertaining the current standing of her accounts, and which is not a transaction as contemplated under the agreements. It seems that they have requested her statements, not just online, like, okay, fine, then send them to me, to ascertain the current standing of her accounts, and she has not been allowed to do so. So why is Wells Fargo so worried about Wendy Williams seeing her financial accounts? And what went down when Williams terminated this financial advisor? Was it a termination and I'm withdrawing all of my money out of your bank immediately and going to bank with somebody else? What is it? What is it? What is it? If Wells Fargo is going to try to say, we are truly and deeply concerned about this individual and the decisions that they are making, freezing things is one thing, but not letting someone see their account statements is on another level. In other words, they say Wells Fargo's actions and the actions of its agents have impeded and unlawfully prevented Williams access to her property. Yeah, money. Although pre-dispute arbitration is required under the agreements, and I appreciate the lawyers putting this in because the lawyers are saying, we acknowledge that we are required to arbitrate, which means they have to go to like mediation. They have to go to an arbiter. If there's any dispute under that client agreement, they have to go to arbitration. And the lawyers are saying, we know that there's an arbitration provision. However, given the imminent and irreparable harm caused by petitioner and respondent's actions, petitioner is seeking injunctive relief. So we're not suing. What we are asking for is a temporary restraining order and a preliminary injunction. Request for relief. They're asking to unfreeze the accounts. We're going to get to the end of the request for relief. They go through the evaluation of petitioners likely to succeed on the merits because they are her funds, and they are saying there is no right for Wells Fargo to freeze them under the plain meaning of the agreement. And then they ask for the court to order enjoining and restraining Wells Fargo and any of their agents at all from freezing all of Williams's accounts, including but not limited to personal, business, deferred compensation, investment accounts, and from interfering with her right to access her financial assets statements pending a final binding decision by an arbiter. So, hey, we will go to arbitration, but you have to unfreeze her shit first. Enjoining respondent and any of their agents, members, officers, employees, and anyone acting on Wells Fargo's behalf from freezing, withholding, or otherwise altering any and all assets that are currently identifiable as accounts and policies which contain funds that were removed and or withheld from Williams's own personal or business accounts and all other funds. And it is more of the same. Unfreeze the accounts, reopen any frozen accounts, stop interfering with her accounts, and then granting such other relief as necessary. That was on February 4th. The next filing was a form order to show cause. The order to show cause that was filed is not filled out. This was just filed as a, hey, Your Honor, here's our proposed order. And this was actually filled out by the court, but we're not there yet. Let us go to Wendy Williams' attorney's affidavit next that was filed on February 9th. This is Wendy Williams' attorney's affidavit. Celeste N. McCaw. Celeste is an attorney licensed in New York, is attorney for Williams, is fully familiar with the facts, submits this affirmation together with the affirmation of Williams, dated February 3rd. I wonder why it took that long to get filed. I'm submitting this affirmation together with the affirmation of Williams in support of the emergency petition for preliminary injunction, temporary restraining order, and other relief in aid of pending arbitration, dated February 4th, by order to show cause for a preliminary injunction. I'm not saying all of that again. February 4th, Hunter commenced this special proceeding by filing the emergency petition, which is attached below, asserting, among others, that Hunter is likely to succeed on the merits regarding the cause of action against Wells Fargo for declaratory relief and breaches of fiduciary duty based on Wells Fargo's refusal to allow Hunter to access her financial assets and property. This is what they are saying they will sue for, but the contract that they have with Wells Fargo, that advisory agreement requires they go to mediation arbitration first, and they can't sue Wells Fargo properly until they do that first. So what they're saying is that these are the causes of action that they will likely sue on once they are able to finish that arbitration proceeding and then go forward from there. But they can't sue yet. But they're asking for this TRO, which would normally be in connection with a lawsuit. They're saying this TRO can't be in connection with a lawsuit yet because we can't file a lawsuit yet because this contract forces us to abide by this provision. So they are trying to abide by the contract while still seeking relief, which I think is appropriate. As explained more fully in the emergency petition that we just went over, Williams is entitled to a preliminary injunction and TRO enjoining and restraining Wells Fargo and all of their peeps and anyone else that acts on their behalf from freezing her accounts, but not limited to personal, business, deferred compensation, investment accounts, and interfering with her right to access financial assets and statements because petitioner can show 1, probability of success on the merits, which is one of the elements, and 2, the danger of irreparable injury in the absence of injunctive relief, which if you were locked out of all of your access to money, you can imagine what kind of damage that could cause to not just you, but your living situation, your long-term financial well-being, your credit score, all of it, like the contracts that you might breach, bills that will bounce and get unpaid, and then fines and fees and penalties that can incur after that. So that is what they're talking about with irreparable injury because you can't undo some of that. And the balance of the equities is in her favor. Hunter can show a probability of success. Hunter already suffered and is in danger of continuing to suffer imminent and irreparable harm in that Wells Fargo's refusal to unfreeze the accounts and financial assets poses a serious financial hardship to the health and safety of Williams, her family, and her business. This petition is being made as request for emergency relief because until Wells Fargo reopens the accounts and allows her access to her financial assets, she, her family, and her business are at risk of imminent and irreparable financial harm while continuing to endure ongoing financial obligations. No prior application has been made. Wherefore all the legal stuff signed by the lawyer lady, and then going on to attach the emergency petition that we just went over. So that was February 9th. Now we get to the affirmation by Williams, but since there is a new one that is signed as an affidavit, I'm just going to go over the new one because the new one is signed as an affidavit. It's going to be a little out of order because Wells Fargo complained about this in their filing. So you'll hear their complaint about it and know that that has now been rectified with this new one. So I'm just going to pull the new one. To my knowledge, all of the facts stated in this affirmation are true and correct. Oh, so they leave the word affirmation in the rest of the place. They had her sign a new one that was notarized, but they only changed affidavit up here. Fair enough. Over 18 years of age. I am petitioner in the above entitled matter, commenced by the filing of the emergency petition for preliminary injunction and TRO and other relief. I submit this affirmation in support of the petition against Wells Fargo. The request for relief arises from, among other things, Wells Fargo's failure and refusal to reopen my personal business and deferred compensation and investment accounts. From here on out, I'm just going to go accounts, and we all know what we mean, and unfreeze my financial assets, which has caused and is causing imminent and irreparable financial harm to myself, my family, and my business. For more than 2 weeks, Wells Fargo has repeatedly denied my request to access my financial assets, which total over several $1 million. I have submitted multiple written requests to Wells Fargo, and I have visited various Wells Fargo branches in the South Florida area in an effort to resolve this matter outside of the courtroom. Can you imagine how angry? I mean, I can't imagine how angry the level of angry I would be. If you're not going to unfreeze it and I have to go to court, at least let me see that you haven't moved my fucking money. The stress that I would have. To date, I have submitted and made over a dozen requests regarding the financial damages resulting from Wells Fargo's decision to unlawfully deny me access to my accounts. As a result of my inability to access my financial assets, I have defaulted and I am at risk of defaulting on several billing and financial obligations, including but not limited to mortgage payments and employee payroll. In response to my request, Wells Fargo, and here's where we learn what Wells Fargo is doing. In response to my request, Wells Fargo has informed me that their determination to deny me access to my accounts is based on the advisement of my former financial advisor, Lori Schiller, who alleged that I was of unsound mind. She's a financial advisor. What does she know? Despite my decision to terminate Schiller as a result of her improper conduct in relation to my accounts, and again, those are allegations. This is Wendy Williams's perspective. Despite my decision to terminate Schiller as a result of her improper conduct in relation to my accounts, Wells Fargo continues to deny me access to my financial assets and statements. If Schiller was concerned, if there was something, giving benefit of the doubt, if there was something that was causing substantial concern, why block the statements? This then goes on to say, as I am in the process of auditing my current vendor and service contracts to ensure that all personal and business relationships are in line with my current needs, which everyone has the right to do, it is essential that I have access to all of my financial property. It appears that Schiller was and is disgruntled by the decision for a potential change in direction. I don't know if that means leaving Wells Fargo or just moving to another financial advisor. I don't know. And it saddens me that respondent and I have not been able to resolve this controversy amicably. To have to go to court over this seems so wild. Given the imminent and irreparable financial damage directly resulting from Wells Fargo's actions, I demand that Wells Fargo reopen my personal, business, and deferred compensation accounts, unfreeze my assets, and allow me access to my bank statements, or else I will have no choice but to seek the court's intervention, which is where we are now. Despite overtures that their in-house legal team would be giving a quote-unquote ruling after I provided them with a properly executed, witnessed, and notarized power of attorney and signed letter of representation as requested, Wells Fargo has yet to advise me of their legal team's decision and has instead engaged outside counsel. I'm assuming, based on this, that was provided because when it says as requested, I'm assuming that they were provided, because it says after I provided them with all of this, they would give me a ruling, but they haven't given me a ruling. So I'm assuming that those things have been done and that she does now have a power of attorney who could deal with this. Nonetheless, despite the urgency of curing the irreparable financial damage in a good faith effort to resolve this matter without the court's intervention, I advise my attorneys to wait until February 3rd before filing the emergency petition. However, Wells Fargo has still failed to reopen my accounts or unfreeze my assets or allow me access to my financial statements. Such failure has caused me and is continuing to cause irreparable financial damages and financial hardship to me, my family, and my business. Until Wells Fargo reopens the accounts and unfreezes the assets, my family and I are at risk of suffering continue irreparable financial harm while enduring ongoing financial obligations. Accordingly, it is respectfully requested that the court issue an order for preliminary injunction and TRO enjoining or restraining Wells Fargo and anyone that works with them from further freezing her shit. So this is then notarized. This was notarized today because Wells Fargo responded and said, well, the information was not notarized, so it is insufficient and the court cannot consider it. All right. The lawyers have filed as of February 9th a letter filing to the judge in the matter of Williams versus Wells Fargo. Dear Justice Bluth, this firm represents Wells Fargo Clearing Services, DBA Wells Fargo Advisors. We're just going to go with Wells Fargo because, you know, the named respondent in the above proceeding. We are writing to ensure that the court is aware of our representation and to facilitate our participation in any application by petitioner for a provisional remedy. TRO and the, preliminary injunction. A courtesy copy of our notice of appearance is enclosed. Yes, it's been filed. I'm not even bothering pulling this up. We also want to inform the court that Wells Fargo has filed a petition in the guardianship part for the appointment of a guardian of the property of the petitioner herein under Article 81 of the Mental Hygiene Law. Whoomp, there it is. Hello, Your Honor. We are Wells Fargo, and we have filed a guardianship or a petition for guardianship of Wendy Williams. The bank did that because anyone can be a petitioner. So they have frozen her assets and have filed a petition for guardianship, which means a court investigator or whatever they are called in New York. I said it earlier. I go with court investigator because that's what they're called in California. But the court appointed individual that will investigate whether a guardianship is needed will now start actually evaluating this. This is now a court proceeding to determine if a guardianship is needed. And when it says a property guardianship, that is a financial guardianship over her money. We would welcome the opportunity to provide Your Honor and opposing counsel with a copy of the guardianship petition. Well, it concerns me that they are saying that Wendy Williams's lawyer does not yet have a copy of what they filed because they are saying, Your Honor, we will provide you and her lawyers with a copy if you would like. What? But we would like to do so under seal or in another manner that will preserve the confidential nature of guardianship proceedings. To summarize without divulging too much on the public record, because yes, this is the public record, Wells Fargo has strong reason to believe that petitioner is a victim of undue influence and financial exploitation. The petitioner is an established client of Wells Fargo and notably 15 years with the particular financial advisor, a 23-year veteran of the financial services industry with an unblemished record. Wells Fargo is relying not only on reports of the financial advisor who has recently witnessed telltale signs of exploitation, including the petitioner's own expressed apprehensions, but also upon other independent third parties who know the petitioner well and share these concerns, which is curious who those individuals are that are talking with the bank. The Financial Industry Regulation Authority, FINRA, which regulates financial service companies such as Wells Fargo, and has become increasingly aware of these types of problems and has encouraged, has encouraged financial institutions to be alert to possible exploitation of their clients and to take preventative action where possible. But then why not give her her statements? Like, even if. So they're saying, look, FINRA is telling us to do this. It's not us. It is this other agency. This is consistent with the New York State Social Services law, which encourages measures to mitigate improper use of an adult's funds, property, or resources by another individual, including but not limited to fraud, false pretenses, embezzlement, conspiracy, forgery, falsifying records, coerced property transfers, or denial of access to assets. What does Wells Fargo think is being... Well, I guess we know what Wells Fargo thinks. They believe they have witnesses of the telltale signs of exploitation, including Williams's own expressed apprehensions, then freeze a transaction, not all the accounts, but also upon other independent third parties who know petitioner well and share these concerns. Who? FINRA Rule 2165, as recently amended, authorizes a financial institution to place a temporary hold on the disbursement of funds or securities where such activity is suspected. That is precisely what Wells Fargo has done here, pending a determination in the guardianship part concerning its client's capacity. As noted, we stand ready to provide Your Honor with the record that will be furnished to the guardianship part. We respectfully suggest to preserve the confidential interest of the alleged incapacitated person as contemplated by Article 81, that the records in the instant proceeding be sealed, at least pending the outcome of the Article 81 proceeding, or that an alternative protocol be established to preserve confidentiality in the interim. File it under seal then. We note that although the current proceeding is styled as one in aid of arbitration, we are unaware of any pending demand for arbitration or pending FINRA arbitration between the parties. It's interesting to me that there is not a demand for arbitration, because all of this seems to say we are anticipating litigation and we will go through the arbitration proceeding first. So it is curious to me that that demand has not been made. It might be because this is much more necessary, but it's just interesting to me. Wells Fargo is merely a stakeholder in this proceeding. It has no interest in the outcome and seeks only to follow the anti-exploitative guidelines of FINRA and the state of New York for that protection of the financial interest and confidentiality of its client. We have little doubt that regardless of the outcome of the Article 81 proceeding, Wells Fargo will have demonstrated good cause for acting in the cautionary manner in which it is proceeding. And I will say, it seems like a lot to freeze everything. It's a lot to freeze everything. And to not give access to the statements is clearly, that's the thing that is troubling me the most, because it doesn't even give someone peace of mind to know that their assets have not been fucked with. If they are deeply concerned, and if they have cause to be deeply concerned, that will not be public record. There is so much that is odd in this, and the way that they've gone about it is also odd. Also, if they say, well, if you get a power of attorney, we will have a determination for you, and then to seemingly ignore that also seems odd. Not turning over the statements seems odd. But you also don't want to see people taken advantage of. But it seems, and I am not deeply familiar with Wendy Williams, it seems that she does have family around her that could help with that. It just seems very, very odd. Let's keep going. There's more. But wait, there's more. So let's see what the court did. The judge has very thoroughly gone through this order to show cause and has decided that there is sufficient cause alleged to put Wells Fargo into proving why they are doing what they're doing. So the judge has said that on the 15th of February, on submission only. So file your documents. What do you have to say? File by submission only why an order should not be entered for a preliminary injunction and TRO pursuant to the law enjoining or restraining Wells Fargo and any of their peeps from freezing petitioner's account, including but not limited to personal business, all the accounts. So the judge is saying, prove it. They are going to have to show why they are freezing this. Then Wells Fargo filed a letter. So this is Wells Fargo's second letter. This is from February 10th. From Wells Fargo. Dear Justice Bluth, on behalf of respondent Wells Fargo, we apologize for further correspondence, but we are concerned about the petitioner's situation and want to reiterate our desire to be heard if the court intends to consider petitioner's attempt to relitigate the issue of a TRO. It is our hope that the guardianship part will imminently appoint a temporary guardian or evaluator to review the situation and ensure that petitioner's affairs are being properly handled pending the applications before Your Honor in the guardianship part. We also note that petitioner's submission in support of her application herein is an affirmation, not an affidavit. Hence the signed affidavit. And her purported signature is not acknowledged. I understand that this tracks. Wells Fargo is saying, we are concerned about undue influence, essentially. We are concerned about somebody becoming financially vulnerable. And so her signature has not been notarized. So because we are worried about impropriety or undue influence, we can't accept anything that is said because it's not notarized. A notary needs to look at your identification, you, and know that what you are signing is you. I understand that part. That part did not trigger me so much because they are saying that their concern is undue influence. That's what they are saying. Aside from the further questions that this rises about the bona fides of this proceeding, about the lawfulness of this proceeding, I mean, are they shadily accusing the attorneys of like being part of this? Because that's odd. Such an unsworn submission carries no weight whatsoever and must be disregarded. Law about that. The motion is not salvaged by her attorney's affirmation because the attorney doesn't have firsthand knowledge. Wells Fargo is open to arranging with petitioner's counsel to release funds directly to the creditors to pay outstanding amounts that have been historically and regularly paid from the accounts in question, such as employee salaries, utilities, and the like. Well, good. Counsel is welcome to contact us, as this is an interim measure that can be accomplished without burdening the court. Finally, we intend to file opposition papers in accordance with the order to show cause, and we will see what Wells Fargo says then, maybe. We believe that the record in this case should be sealed to protect the petitioner's privacy, and pending such a sealing order, we would appreciate permission to email our responsive papers directly to Chambers. Well, file them under seal then. Would you please let us know if this is possible? The guardianship part has approved our request, which means there is now an investigator, pending hearing of the full guardianship application to utilize an anonymous caption in that proceeding. Meaning in that proceeding, they are moving forward under anonymous captioning, so it will not become public and it will be private. I'm always frustrated when court proceedings are private, but I also understand that not everything needs to be everybody's business. And I struggle with the two sides of that. The public wants transparency, but also individual humans have a right to privacy in their affairs. Let us see what the letter from Wendy Williams' attorney says. From Miami Entertainment Law Group, which it's interesting to me because the things that have been signed in Florida. So it seems clear that Wendy Williams is in Florida at the moment, even though this is being filed in New York and she's a resident of New York. But this law group operates out of both New York and Florida. So I don't know what the ties to Florida are, but all of this, it was notarized in Florida. In the declaration, it's talking about going to the branches in Florida. This Miami Entertainment Law Group is based in Florida, but this attorney's barred in New York and Florida, which probably makes that easy because there's lots of crossover between New York and Florida. So, dear Justice Bluth, we submit this further correspondence to the court on behalf of petitioner as her counsel in the above caption mattered. Due to the urgency of the relief requested, our client was unable to notarize an affidavit prior to our filing of the emergency petition, which is why we proceeded with her affirmation. However, it was and remains our intention to present a properly executed and notarized affidavit by petitioner to this court at a hearing on this matter. They submitted it anyway. However, as such hearing has not yet been directed by the court, we have enclosed a courtesy copy of petitioner's affidavit to address opposing counsel's concern about her unsworn affirmation. While our client appreciates respondent being, quote, open to arrange to release funds directly to the creditors to pay outstanding amounts that have been historically and regularly paid, end quote, it calls into question why such historically and regularly paid outstanding amounts ceased in the first place if those bill payments were not subject to suspicion of undue influence or financial exploitation, as they have alleged to this court and in a guardianship proceeding, again, of which neither our client nor her designated power of attorney have received any service of process for or have any knowledge of being commenced. Here's the key part of that sentence. In a guardianship proceeding, which neither our client nor her power of attorney have received any service of process for or have any knowledge of it being commenced. They said her client and her power of attorney have not been provided service of process that the guardianship proceeding has commenced. She has not been given notice that a guardianship proceeding has commenced. It does not say, though, that her attorneys haven't. It says very clearly neither our client nor her designated power of attorney have received service of process for or have any knowledge of it being commenced. They have not given her notice of a guardianship proceeding being commenced against her. Generally, notice is required, but you can seek to have notice waived. The reason I am so triggered is because they also had the court waive notice for Brittany. Wells Fargo did say, to go both sides, Wells Fargo did say in their other letter that they would, as a courtesy, provide her lawyers with the guardianship proceeding information, which is when we were going through that, when I said, oh, do her lawyers not know? Have they not been provided? There's lots of information in these. Nonetheless, we request an order directing the immediate release of those funds by Wells Fargo, and we also reiterate our request before this court to have a hearing to, among other things, avoid any delay in bill payments being made due to any potential dispute between the parties as to whether any outstanding amount is, quote, historical or, quote, regular. We thank the court for its kind consideration of this matter, and then they enclosed the sworn affidavit that we covered. That's the whole record. So the questions that remain in my mind are that the agreement that they signed authorizes them to suspend transactions. That doesn't seem to account to suspending the entire account and all of the assets. However, I wonder if when the financial advisor was fired, if the intent was made clear to move all of the assets elsewhere. And that is the transaction that we are now contemplating, or that Wells Fargo is contemplating, that Wendy Williams was saying, I'm going to move all my assets away from you fuckers. I'm done. And that they were like, no, we have questions. But with that, they might have, and I don't like it, but they might have decided, hey, part of the reason we are not giving you a full breakdown and bank statements is because we believe there is malfeasance or undue influence. And so we're not going to show you where everything is because we don't want other people to know that there isn't, is. It is a tremendously odd situation to see a bank filing for guardianship proceedings. What we should see is an investigator from the guardianship court to then investigate whether or not a guardianship over finances is proper or improper. In the meantime, it's a point well taken for me by Wendy Williams' lawyers to say, hey, I don't want Wells Fargo deciding what bills get paid and what bills don't get paid. Let her pay her bills, because that also seems to be sus. So, with all of it, I have a lot of questions. But at this point, though I do not like what Wells Fargo is doing, they are allowed to file under New York law a petition for guardianship. It's odd to me, but it might end up with like, okay, but she has a power of attorney, and we're just going to do all this through her power of attorney. Unfreeze her accounts and deal with her power of attorney. And that might be proper. Wendy Williams is fighting with Wells Fargo over her frozen assets. Their motion to seal the case has been granted. So everything is now sealed, which means we are not going to know much more about this case. And that just makes me so mad. Why does it make you so mad, Emily? Well, part of it is that in the Britney case, we saw how much wildness went on. And I'm not saying that this is going to be like that, but I think transparency is one of the things that helped in the Britney case, because others could see what was going on and others are not going to be able to see what's going on here. I completely understand that sealing documents that talk about specific medical concerns should be sealed. It is no one's business, specific details, but those things can also be redacted. Sealing the entire file is a lot for me, because there are two parts of this. There is the motions with Wells Fargo to unfreeze the assets going on. And then there is the second part of it where Wells Fargo is asking for a guardianship, which is essentially a conservatorship. It's just same thing, different name. I don't love at all that the entire case in not the conservatorship part, not the guardianship part, the entire case where they are suing for a preliminary injunction and temporary restraining order to have access to Wendy Williams's funds, it keeps everything out of the public eye. And again, I think there is room to redact information. I think there's room to redact specific medical or financial information. I think sealing the entire thing is a big move. I try to trust that the courts have people's best interests in mind, but also sometimes I've been burned by that. So I'm just concerned and nervous about what's going on here. I am trying to be optimistic, but all we know is that on February 16th, the court has sealed it. I'm going to keep checking in on it, and maybe Wendy's legal team will fight this ruling to seal everything instead of just sealing parts of it. This is something Wells Fargo asked about and was granted. So, okay, so there's that. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.